Good afternoon, everyone, if you're on the East Coast. Good morning if you're on the West Coast, and good evening if you're in Europe or Asia. Welcome to the December 2021 TSCA 3030. And we appreciate you joining us today because there's only 16 shopping days left for Christmas. So we appreciate you taking time out to listen to us. We have a special program today. It's called TSCA Litigation in the Biden Era. As you may know, there was a great deal of TSCA litigation during the Trump era, largely by NGOs that were trying to turn back almost every Trump administration initiative. But surprisingly, there's a fair amount of litigation now that the Biden EPA has taken charge. Next slide, please. I'm Herbert Stryker. I do most of these. Next slide, please. I'm joined today by my partner, Eric Gotting. Now, Eric is one of our litigators, environmental litigator, and we do environmental litigation. So although we're primarily a regulatory firm, we do have a litigation group, and we're pleased to have Eric here. I'm going to turn this over to Eric, and then I will do the next topic after he does his. Eric?
Thanks, Herb, and thank you for joining us today. I'll be discussing some of the major ongoing litigation out there involving TSCA, and in particular, the litigation involving some of EPA's risk evaluations and risk management rules. As of right now, you can divide these into kind of three categories with stakeholders who are largely opposed to TSCA's implementation under the Trump administration, leading the way and going to great lengths to change the course of TSCA implementation. So first, there are challenges involving Trump-era risk evaluations on 3 of the original 10 chemicals, and those being methylene chloride, HBCD, and 1,4-dioxane. And second, there is an ongoing challenge to a Trump-era PBT risk management rule for DECA BDE. And then finally, there's litigation surrounding the asbestos risk evaluation, including what are known as the Part 1 and Part 2 evaluations. And what we see coming out of this litigation are several themes. First, that the courts have been extremely deferential to EPA in terms of the timing and substance of EPA's efforts to reevaluate these risk evaluations and risk management rules. Second, that after or following their partial victory in the Safe Chemicals Healthy Families decision out of the Ninth Circuit, things have kind of slowed down somewhat for the NGOs and the other challengers. So we will discuss that in some more detail. And then third, despite these temporary setbacks, the NGOs and the other challengers are slowly chipping away at whatever victories the chemical industry achieved during the Trump administration. And depending on how EPA's re-reviews of these various evaluations go, these NGOs and the other petitioners are setting themselves up for further litigation down the road if needed. And this is important. Just as the Ninth Circuit's decision in Safer Chemicals Healthy Families significantly increased the scope of conditions of use that must be considered in risk evaluations, at least for some types of chemicals, the outcome of these cases, the ones we'll talk about today, could have a significant impact on how risk evaluations and risk management rules proceed in the future. Next slide. So the 3 risk evaluation challenges involving methylene chloride and HBCD and 1,4-dioxane have all largely followed the same script. These cases have been consolidated in front of various panels of the U.S. Ninth Circuit Court of Appeals. And there's a lot of overlap among the petitioners, which include environmental groups, Democratic-led states and municipalities, unions, Native American tribes, and other special interest groups. Next slide. So these cases all challenge multiple determinations by EPA that the respective chemicals, at least for some conditions of use, don't present an unreasonable or don't pose an unreasonable risk. So while there isn't complete overlap among the various cases, most involve challenges based on the same claims that the Trump administration evaluations fell short. So these involve certain policy choices made or taken by EPA, for example, assuming that workers always have access to and use PPE, which can lead to lower exposure estimates in the evaluation. EPA declined to consider certain susceptible subpopulations like fence line communities Native American tribes, firefighters, and those with genetic vulnerabilities, failing to consider certain exposure pathways to the general population, namely through air, drinking water, and soil exposures, under the assumption that these are adequately regulated under environmental laws, and then making no unreasonable risk determinations based on the use-by-use approach. In other words, looking at each condition of use separately, rather than making one call based on the chemical's risks as a whole, or the whole chemical approach, as we call it. So on top of that, these challenges also involve more specific case-by-case allegations regarding shortcomings in the evaluations, such as that EPA failed to consider certain health and safety information that was before it. It failed to consider combined exposures from multiple conditions of use. In other words, they were just looking at each one individually, and then failing to consider certain disease endpoints. So next slide. So none of these proceedings, however, have come close to decision. In fact, only one set of briefs has been filed in any of the proceedings, and that was the set of opening briefs filed by petitioners in the methylene chloride case. So EPA hasn't filed any merits briefs in any of these cases. So instead, what is happening is that EPA is engaged in kind of a time-honored tradition at the beginning of any new administration of essentially mooting, at least temporarily, litigation challenges to decisions made by the old administration, the prior administration, so that the new one, Biden, can reconsider those decisions. So in all three cases, EPA has asked the courts, or the court, the Ninth Circuit, to remand the risk evaluation back to the agency without what we call vacatur. So in other words, the court would keep the Trump risk evaluations in place for the time being, while EPA reconsiders prior policy choices and approaches. And EPA based these requests on a number of grounds. First, they were ordered to do so by an executive order, EO 13990, by the Biden administration, which kind of applies across the government. Second, the reevaluation in EPA's mind might eliminate or at least narrow the issues that eventually have to be litigated. So as many of you know, Assistant Administrator Friedhoff has made several public statements, including the June 30th press release or statement that EPA would be revisiting the 10 initial risk evaluations, including revisiting this PPE assumption, applying the whole chemical approach instead of a condition of use by use approach, evaluating additional exposure pathways, even if they are regulated by other environmental laws, and then considering susceptible subpopulations. And in statements to the various Ninth Circuit panels, EPA more or less said it would consider these matters if these evaluations are remanded back to the court or back to the EPA. So the third reason was that the agency would accept further public comment on these risk evaluations, including on the alternative policy choices and approaches. So all in all, EPA argued to the court that it should have a chance to apply its expertise to these matters and have adequate time to reconsider all of the issues without being burdened with ongoing litigation. And so the petitioners then, of course, opposed these motions. So overall, they complained that EPA had not promised to actually make any changes to the evaluations or to do so by a certain date. They said that further delays would mean that consumers and workers would continue to be exposed to these chemical substances. They argued that the issues that they were raising were broad first impression, statutory interpretation questions that would apply to all risk evaluations. And so the court should take the time now to decide these questions so there was no confusion or wasted time going forward. And they worried that if the evaluations were not vacated, that industry would argue that any existing or future state restrictions would be preempted under TSCA by the no unreasonable risk findings. And while they didn't specifically identify any state restrictions that would be preempted for methylene chloride and HBCD, they did cite to New York's recent legislation that would regulate the levels of 1,4-dioxane in personal care and cleaning products. So in the alternative, the petitioners demanded that the court vacate all the findings of no unreasonable risk. So those would be wiped off the books. They asked the court to set strict timetables for EPA to meet in any reevaluation, require status reports to the court, and to set strict deadlines for any future risk management rules. So next slide. But in the end, the Ninth Circuit deferred, as I mentioned earlier, to EPA. In all three cases, the court remanded the issue back to EPA without vacating the risk evaluations. So the agency could reconsider the findings of no unreasonable risk. The court required status reports every 90 days and otherwise placed the cases into abeyance pending the outcome of the review of the risk evaluations. So this goes to show just how deferential courts can be to agencies when there are outstanding policy questions and issues that require an agency's expertise and judgment. So courts oftentimes want to ensure that the agency has had sufficient time to make decisions and build a full administrative record before the court ever gets involved. So at least at this point, the petitioners aren't getting what they want, at least in the courtroom. The Trump risk evaluations are technically still in place, thus potentially impacting any future preemption claims. And EPA is not subject to any deadlines. So EPA estimated for most of these 12 to 18 months to complete these reevaluations, although I think it was for the HBCD, EPA said that in the coming weeks, they would be issuing a notice for public comment. But nevertheless, we all know agencies move very slowly, so we could see this turning into a drawn-out process. Now, that said, the petitioners may, in the long run, fare better. We know EPA has committed to at least rethinking these key issues regarding risk evaluations, including the whole chemical approach, the assumptions regarding PPE, the consideration of exposure pathways for the general public, and things like that. So they may, meaning the petitioners, may get much of what they want in the reevaluations, although that remains to be seen. And these cases aren't over. If the risk evaluations don't meet their demands, the petitioners can ask that the abeyance be lifted or file new lawsuits. So while this is a slow-moving train, from their perspective, the petitioners are setting this up for further litigation if needed. Next slide. There is also a challenge in the Ninth Circuit involving the risk management rule for PBT, DECA BDE, which is a flame retardant that went straight to the risk management stage under TSCA Section 6. In other words, there was no risk evaluation done. And so here the petitioners are challenging what they call loopholes or exceptions that would allow the continued use of this chemical, including an exception for recycling products that contain DECA BDE and allowing the use of those recycled materials again in commerce. So like the risk evaluation litigation that we discussed, there's been no briefing yet. So we're kind of at the beginning of this case. And EPA asked and was granted by the Ninth Circuit several temporary stays of the litigation to seek public comment on the risk management rule. And the first stay, which was unopposed, ended in July, and the second stay, which was opposed by the petitioners, ended in October. So again, the petitioners complained that any further delays would lead to continued exposures, and that there was no guarantee that EPA would actually fix what they think is wrong with that risk management rule. But this is where this case diverges from the cases involving the risk evaluations. The parties recently filed a joint motion to set a briefing schedule that would have all briefs being completed by late June 2022. And the court has yet to rule on that motion. So here the petitioners are at least getting their day in court. EPA is still reviewing the public comments that were submitted, so perhaps it will be able to moot some of this before briefing is done or make decisions that will result in an entirely new risk management rule that will raise a whole new set of issues that the petitioners will want to challenge. Finally, I quickly note, even though it's not on the slide, that some industry groups have also challenged the risk management rule for PIP 3.1 in the DC Circuit. And those cases have been held in abeyance until at least March 2022 so that EPA can continue evaluating some public comments and the need for an extended compliance date. So industry is also involved in some of these cases, but not to the extent that those who are opposed to the Trump administration's rules are. Next slide. So the final piece of litigation involves asbestos. So as many of you know, the Trump EPA only conducted a risk evaluation on chrysotile asbestos in what is now called the Part 1 risk evaluation. And so EPA originally limited the evaluation because it had promulgated a framework risk evaluation rule that excluded from consideration all legacy uses and disposals. And chrysotile asbestos was the only form of asbestos that was still being manufactured and distributed. In other words, it wasn't a legacy use type product. But because the Ninth Circuit held in 2019 in the Safer Chemicals, Healthy Families decision that certain legacy uses and disposals must be considered, EPA said it would conduct another risk evaluation called Part 2 that would evaluate other forms of asbestos as well as covered legacy uses and disposals. So two pieces of litigation have grown out of these circumstances. First, a citizen suit was filed under Section 20 of TSCA in the Northern District of California, claiming that EPA had failed in carrying out its non-discretionary duty to fully evaluate asbestos by the statutory deadline of June 2020. And the Part 1 evaluation didn't come out till later in December 2020. So the petitioners in that case are asking the court to order a complete evaluation and that it be done on a tight schedule. And second, the same petitioners filed a suit in the Ninth Circuit challenging the Part 1 evaluation and the EPA's failure to consider all forms of asbestos. And so just recently, these cases settled, or they're getting to settlement. A consent decree was entered in the Northern District of California proceedings, and the Ninth Circuit case has now been held in abeyance as EPA has agreed to complete the Part 2 evaluation by December 2024. So unlike the three other proceedings involving risk evaluations, the petitioners have largely gotten what they wanted as compelled by the Ninth Circuit ruling in Safer Chemicals, Healthy Families regarding legacy uses. And so this is a good example of the strategy being used by these petitioners in this litigation. You can see that an industry loss on a broad issue of statutory interpretation, in this case, the legacy uses, can drive risk evaluations going forward. And so it is important for industry to keep monitoring not only EPA's reevaluations of these initial chemicals, but also if and when litigation starts up again, to make sure that industry has its say. And that can be done through filing petitions for review, through intervention in the existing cases, or through amicus briefs. So that's it. So I'll turn it over.
Well, actually, I have some questions, Eric, if I may.
Okay.
I mean, I had read somewhere that industry was petitioning to intervene in some of these cases to take over the Trump positions. Is that true?
So actually, surprisingly,
yeah,
there have only been a couple of either amicus briefs or interventions. I think the only intervention by industry is in the asbestos cases at the Ninth Circuit by the Chloride Institute. But surprisingly, there have been no other interventions in any of the other cases, except I think methylene chloride has ACC, the Halogenated Solvents Industry Alliance, and another smaller trade group. But that's it. So you have methylene chloride and asbestos.
Don't you find that somewhat surprising, given the fact that the issue in these cases is a no unreasonable risk determination?
Absolutely, because the Ninth Circuit's decision and Safer Chemicals shows if they win on a broad issue that is going to cut across all of these risk evaluations and risk management rules, that gives those folks an incredible amount of leverage going forward. And so, industry is going to be best served by making sure that it has its say in these cases to make sure that the courts and EPA properly interpret the TSCA amendments.
Why do you think it is that industry is not really getting involved? I mean, is it because they don't feel they have a stake in these particular chemicals? But that seems somewhat short-sighted if there are general principles of statutory interpretation that are an issue there.
Yeah, I think as a practical matter, EPA has said it's going to reevaluate these risk evaluations and that public comment will be available. So perhaps, industry is thinking, we're not quite there yet. We need to, there's another round here before EPA, before we get back to the litigation. So, they can file comments and participate in that process and build the administrative record that will then be reviewed by the court on kind of the second round, so to speak.
Yeah, but let's say, for example, there's a no unreasonable risk determination that's in one of these cases now that's overturned by the courts, and then what happens?
Well, it wouldn't be it wouldn't be overturned by the court. EPA in its reevaluation would reevaluate and come up with a new evaluation. Let's say now there is an unreasonable risk. Then industry, assuming that it's played a role in that public comment process, could challenge that finding.
I see.
Whether it's in one of the existing cases or a new case.
Okay, so in these cases, have they any of them progressed far enough where where we're really getting into the science before the courts, or is it all just
not yet? Because they've all been remanded. So at least the first three that I talked about, the PBT rule is actually going to be briefed.
Okay.
So we will soon get to that point in that case where the science is being argued.
Okay. Oh, but we don't have the opening brief, so they don't even know what the issues are.
Yeah, I mean, you can go back to the public comments.
Get some idea what they were proposing. Okay, tell me something about the PIP 3.31 challenge by industry. What were they complaining about?
So we're actually not sure because only petitions for review have been filed, and those are very short. It's not like a complaint.
One-page thing.
Yeah, it's like a one-page.
I'm not happy. I'm unhappy.
Yeah, I'm not happy, but they don't say why. So we're actually not clear on what those trade associations. There's a series of them that have filed the suits.
Well, you know what the PIP 3.1 story is, that the deadlines were impossible to meet. But of course, that's all been kind of mooted out because EPA's extended the deadlines, and they now to 2023, I think it is, or something like that, or 2022 sometime. And then they're going to engage in a new rulemaking. So hasn't that all been mooted out, that case, or is it? That's still
been completely mooted out. I think the extension is until March 2022, so it's not that long. But yes, they're reconsidering all these public comments. And I think have committed, or maybe not committed, but at least have said that they are thinking about further extensions. And so it's kind of like a temporary mooting.
So industry's really only achieved, NGOs have really only achieved one victory in this asbestos case, the Section 20 case, where they basically prompted EPA to do something that the NGOs wanted. Is that right?
Yeah, and that's because they won.
Yeah.
Safer Chemicals, Healthy Families case.
Got it. Interesting. Okay, next slide, please. So I want to talk a little bit about TSCA 21 petitions. And I'm also going to talk about Section 20 petitions. I don't have any slides on that. Back to I give some remarks on it anyway. So I had predicted, could you go back to the previous slide? I had predicted, I know it's published in the trade press, I think all three of them, that there'll be a lot of Section 21 petitions during the Biden administration. Because number one, I think EPA was embroiled in this fluoridation case before Judge Chen in the Northern District of California, and still embroiled in it, being held on hold now. The case has been stayed. But things didn't look too good for EPA, quite frankly. I mean, Judge Chen was, very critical in what EPA had done in denying that petition. It remains to be seen what will ultimately happen. But I think at a minimum, EPA is going to have may engage in a rulemaking process on fluoridation. And so, given the fact that the NGO showed that they're willing to litigate these Section 21 petitions, given the fact that at least you could find some judges that are receptive to all this. Remember, it's a de novo review. Given the fact that we now have a very pro-environmental administration, I would have expected to see lots of Section 21 petitions, and I would expect to see EPA grant them. But that's not what happened. Next slide. Yeah, so we'll go through the four, I think, that were filed this year. And for people who want to know how the outcome, they were all denied by EPA. So the first two were kind of, in many ways, foolish petitions brought by a single individual, which will show you that an individual can sort of tie up EPA resources by sending in a letter saying that I petition, which is an interesting kind of thing. And I was surprised that there isn't more of that. But this year, in the summer, EPA received a petition from an individual asking EPA to determine that cosmetics pose an unreasonable risk to the healthy environment, and also asking EPA to issue a rule of order to eliminate hazardous chemicals that are used in cosmetics. And basically, EPA denied the petition quite rightly because, as you know, and everybody knows, cosmetics are not within the scope of TSCA. And then, interestingly, they also said that the petition did not demonstrate facts that could support an EPA determination of unreasonable risk to the environment from the disposal of cosmetics, which I think actually is the first time EPA has ever said that disposal of cosmetics is within the scope of TSCA. So I'm not sure what EPA's position has been on other FDA regulated products, but it's made it clear in this case that it considers cosmetic disposal to be within the scope of TSCA. Next slide, please. Same individual, roughly a week earlier, filed a petition, also kind of a foolish petition, asking EPA to basically ban the chemicals or additives they're using in tobacco, and to eliminate those additives that are hazardous, and develop techniques to ensure that, I guess, cigarette butts degrade the environment. And EPA denied the petition because it said, full stop, that cigarettes are not a product that could be regulated under TSCA. Because, as you know, there's a tobacco product exemption from TSCA. Whether that covers e-cigarettes is a separate question, but there certainly is a tobacco product exemption under TSCA. Interestingly, this parallels a case that was brought by anti-gun advocates a number of years ago to require EPA to eliminate lead in bullets, in ammunition. And you know, there's a guns and ammunition exemption from TSCA, but that case was actually litigated and went pretty far until a court finally said, no, EPA has no jurisdiction on the guns or ammunition. So that's kind of an interesting thing. Next slide, please. The third one was a little bit more serious. It was filed by a variety of NGOs, and they wanted EPA to regulate phosphogypsum and processed wastewater under Section 6, Section 4, and Section 5. Actually, just a snippet of the use rule under Section 5, and it required prioritization under Section 6. EPA rightly said that Section 21 doesn't permit a petition for a prioritization decision under Section 6B. It only allows for a request for rulemaking under Section 6A, but EPA decided that it would consider that petition to be filed under the APA, the Administrative Procedure Act, rather than TSCA 21. And then for the significant use rule under Section 5, EPA rightly concluded that Section 21 does not allow a petition for a rulemaking under Section 5. In terms of Section 4 rulemaking, EPA basically gave the end of the response that the petition did not demonstrate the fact that there was insufficient information to warrant testing. And so as a result, EPA denied that one as well. Next slide, please. And the last one was actually filed. This is really a Trump one. I apologize for that because I didn't check the dates. It was actually filed in October 2020. It was denied January 7th, 2021. So Trump was still in office. And so since I'm running out of time, I'm not going to go into this one. But this is the request for is basically NGO strategy, which has been pursued in litigation around the country involving PFAS, where they would like the companies that manufactured the PFAS or manufacture PFAS to basically fund studies and to submit those studies to an independent panel of scientists. And that's a litigation strategy that they've been pursuing all around the country in different cases. And they basically threw that same litigation strategy at EPA in the Section 21 petition, which EPA denied. Next slide, please. So I like to, in 5 minutes, we have our REACH 3030. We're going to give an update on the polymers requiring registration. So if you're interested in polymers, as you know, the Europeans are considering requiring registration of polymers. Currently, only the monomers and the polymers are subject to registration, but they're going to be requiring registration of polymers. And if you import ship polymers to Europe, it's going to be a very, very expensive exercise for you. So I suggest that you stay on. And we're also going to talk about a few other things in terms of some enforcement initiatives in Europe. There is a call to have legislation to encourage companies to whistleblow, or employees in companies to whistleblow on companies, or to whistleblow on competitors if they're in violate REACH. And so there are a lot of interesting developments in that score in Europe. And if you're interested in any of that stuff, I suggest that you stay on. Our next TSCA 3030 is January 12th. We have, as always, our OSHA 3030 middle of the month of December. And then tomorrow, if you're interested in this issue, we're having a webinar on the American Disabilities Act and lawsuits involving website accessibility. And that's actually a theory that, websites should be designed to be accessible, to people with disabilities. So that's a new kind of litigation. And I guess we have a lawyer in California who's involved in a lot of these ADA lawsuits, and he thought that would be broadly interesting to people. Next slide, please. So I'm Herbert Stryker, and I was joined today, very pleased, to one of our litigators, Eric Gotting, who I think did a bang-up job. And for those of you who are staying on the REACH topic, I'll see you in 5 minutes. But if you're not, then maybe I'll see you next month, or maybe it'll be one of my other partners. Take care, everybody. Have a great Christmas. Bye-bye.